I'm sure everybody's heard the terms patent and copyright and trademark and things like that. Tell us a little bit, what's the difference between a copyright and a trademark?
Sure. So I'll start with patents because that's the one people tend to know about. If you invent a new invention, new car, new truck, new chair, new gizmo, that's usually what people think of when they think of a patent. You can patent an invention. If your business has a name, you can trademark the name to stop people from copying the name. And if you come up with some new creative work, like you write the next great American novel, or you write some software code, or you draw a drawing, or you make a painting, those things can be copyrighted. So copyrights protect creativity, trademarks protect names, and patents protect inventions. And that's the 10,000-foot view of how that all works.
Okay. Now, when you're talking about patents, are there certain, does it necessarily have to be an invention or an actual device or a thing that you would get a patent on?
Not necessarily. Most patents are that. They're called utility patents, and that's what people tend to think of when they think of patents. You can also get patents on designs. Way back in the day, the classic Coca-Cola bottle, the classic shape, that had something called a design patent, where you just patent the shape and the look of the industrial product. The iPhone has a patent just on the shape. So if you have an industrial design for some product that you sell, that's definitely something you can get a design patent on. If you make a new plant, you can get a plant patent on that. Most people don't do that, but that is an available thing as well. So there's three kinds of patents. You have utility patents for inventions, design patents for designs, and plant patents for plants.
Okay. Now, I'm sure you've heard the term necessity is the mother of all invention. I'm sitting there thinking to myself, you're watching TV and you see somebody come up with a product, and maybe it's like a modification of something that you already do, or maybe you're somebody like my wife who can find these regular devices and somehow switch them up and turn them into something that comes up with a different use. What would you do if you have a situation where you take a common product like you have in the house and you say, hey, this is really good for this other thing if I were to make these modifications, and you basically alter an existing design? Is that the type of thing that you would necessarily need a patent for?
You can. Do you need a patent for it? You need a patent only if you intend to make or sell or use this thing that you created. So if you've found some design and you've made an improvement to it, and this improvement really is something new that has never been done before, you may want to consider seeking a patent if you intend to commercialize that product. There's another side to that, and that is, even if you get a patent on this new twist that you've put on this idea or this design that's already existed, you may still need to get a license from the older technology, the person who owns the older technology, before you can actually sell the newer technology, because in a sense, the old technology is sort of built into that new technology, if that makes any sense.
Yeah, I think I understand what you're saying there. If anybody has a question about intellectual property, trademarks, patents, copyrights, you can give us a call. We're taking your calls live at 850-392-1544. Jared, one of the other things I was thinking about, we have a lot of different industries in the area. We have a lot of technical industries in the area. What if you, say, work for somebody and they design a widget, but in their spare time they do their own work, somewhat similar but not necessarily the same work they're doing for their employer? Is that something that, number one, is it allowed? And number two, is that something that you could somehow, if you come up with a design outside of work but it's very similar to what you do at work, is that something that you could put a patent on?
I've run into this issue before, and the rule of thumb is that if you are an employee for a company and you invent anything or you design anything that's very similar to what you do at work, it's very likely your employer is going to try to claim what you have designed as their intellectual property. That's the rule of thumb. And nowadays, people working on their smartphones, on their laptops, oftentimes those things are provided by their employer, or the employer pays for part of the cell phone or pays for Wi-Fi. People who are in the design world or the technology world, it's tough to prove that you designed something totally on your own time, totally with your own stuff, and it has no